and housing consequences you should know. Today's presenters are Karen Pillar from Teen Child and Kim Ambrose from the University of Washington School of Law. This webinar gives a brief overview of housing rules and regulations and how they affect youth who are involved in the juvenile court system or people who already have juvenile records. This webinar is not legal advice, and you should consult an attorney with questions about your specific situation. There are additional resources available in the box to the right that can provide more detailed information. A young person pleads guilty or is found guilty in juvenile court. That young person is adjudicated. This court decision and many of the documents related to the case become the youth's juvenile record, or sometimes called a criminal record. Some people think juvenile records are private and not something the public can find. That is not true. Anyone can look up a juvenile court record and find out about someone's adjudications or convictions, as well as arrests, dismissals, and diversions. Landlords often look up criminal records, and landlords can make decisions about whether to rent to someone based on their criminal record. Landlords can look up the criminal records of the children who will live with an adult who is seeking a rental. It is not against the law in Washington State for a landlord to decide not to rent to someone based on their juvenile record. When applying to rent an apartment, everyone should be honest when asked about juvenile records. Lying on a housing application can be a reason to evict a renter. It is also legal for a landlord in many circumstances to decide to evict a renter if the renter is convicted of a crime while renting from the landlord. We will cover the details of these rules in the next few slides. Some of the rules depend on whether you are in private or public housing. A private landlord can be an individual, or it can be a company or business. The key is that the landlord is not a government agency. A private landlord can be a person who owns a house and rents it to others, or it can be an individual that owns an entire apartment building and rents out each apartment. A private landlord can also be a company that owns an apartment complex, or a mobile home park, or a development of homes that are for rent. Private landlords have more independence and authority to decide whether to rent to someone with a criminal record than public housing agencies do. They also have more authority to decide whether to evict someone who has been convicted or adjudicated of a crime. Private landlords are allowed to deny rental to anyone with a criminal history. This is true even if the person renting is a parent and the person who has the criminal record is a youth who lives with the parent. When a landlord screens applicant's criminal record, the landlord must tell the applicant in advance that a criminal background check will be conducted. The landlord must also tell the applicant what kinds of reasons could cause the landlord to reject the applicant for the rental. Furthermore, a landlord can make the terms of a lease include the right for the landlord to evict a household or a member of the household for criminal behavior. As you can see, getting a juvenile record can have significant impacts on a family's ability to have stable housing. We will share ideas for trying to overcome the challenges a juvenile record can have on housing in later slides. Housing means housing that is paid for by the U.S. Department of Housing and Urban Development, or HUD. There are different types of HUD programs, and they are generally administered
through local public housing authorities, or PHAs, like the Seattle Housing Authority or Tacoma Housing Authority. There are publicly owned and operated housing programs, apartment complexes like New Holly in Seattle or Salishan in Tacoma. There are also private landlords that accept Section 8 or housing choice vouchers that are assigned by PHAs. Different public housing providers may have different rules. The rules will govern whether you can get into public housing with certain juvenile records and whether you can be evicted from public housing for being found guilty of a crime as a juvenile. Under federal housing laws, juvenile adjudications are treated the same as adult convictions. Public housing authorities may, but are not required by federal law, evict an entire household for the criminal activity of a juvenile or adult household member if the activity threatens the health, safety, or right to peaceful enjoyment of the premises by other tenants or by other people who live in the immediate vicinity. This is very broad and gives the Public Housing Authority a lot of discretion. You don't have to be found guilty of a crime, but public housing authorities are not supposed to rely just on arrests when making a decision to evict you. Families can also be evicted from public housing if any household member commits a drug or violent offense, even if it doesn't happen on the premises. In those cases, the Public Housing Authority does not have to show a threat to the residents or those who live nearby. Also, the Housing Authority can evict the entire household, even if some of the members did not know about the criminal or drug activity. Sex offenses committed by juveniles can result in an eviction and will be discussed more a little later. Federal law also allows for the eviction of households that include a juvenile who is a fleeing felon. A fleeing felon is someone who has a warrant for failing to appear for a felony prosecution, or someone who is violating the conditions of their probation or parole.
Even if you don't currently live in public housing, a juvenile adjudication can prevent a household from getting into public housing or getting a Section 8 voucher in the future. In public housing, there are laws that are called mandatory bans from public housing and discretionary bans from public housing. What this means is that in certain circumstances, the Public Housing Authority must refuse to rent. These are the mandatory bans. Or may refuse to rent. These are the discretionary bans to households where someone has committed certain types of crimes. There are 4 different circumstances where public housing authorities must refuse to rent. First, when one of the members of a household, whether an adult or juvenile, is subject to lifetime sex offender registration. More specifics about how juvenile sex offenses affect housing will be discussed later. Second, public housing authorities must refuse to rent to households where a member was convicted, as a juvenile or adult, of manufacturing or otherwise producing methamphetamine on the premises of a federally assisted housing program. Third, public housing authorities must refuse to rent to a household that includes a member who has been evicted from public housing for drug-related activity. This ban must last for 3 years from the date of that eviction, unless they can prove that the person completed a drug treatment program that was approved by the Public Housing Authority, or the household can prove that the person involved in the drug activity is no longer part of the household. Finally, public housing authorities have to have policies that state the housing authority will refuse to rent to individuals, adults and juveniles, who they know are engaged in illegal drug use or a pattern of drug or alcohol abuse. Public housing authorities can look at past criminal history, rental history, or other evidence to make this determination. A public housing provider may refuse to rent to any household which includes a member currently engaging in drug-related or violent criminal activity. This is also true if the household member had recently engaged in this type of activity within a reasonable time before being a renter. The rule includes language that says any other criminal activity which would adversely affect the health, safety, or right to peaceful enjoyment of the premises by other residents, the owner, or other public housing agency employees could be considered as reason to refuse to rent to a household. Although there are many barriers to accessing public housing with a juvenile criminal record, there are ways to seek some relief. Later, we will provide some ideas on how to get help if a juvenile criminal record creates barriers to public housing.
Juveniles who are found guilty of sex offenses have to register with the county sheriff, just like adults do. This results in them showing up on sex offender registries that private landlords and public housing authorities can access and use to deny them housing. Juveniles who commit the most serious sex offenses are subject to registering indefinitely. This means that they have to register until they ask a court to remove this obligation. This process requires a waiting period, depending on the offense, and the person has to show that they have been rehabilitated. The process is difficult to do without an attorney, and unfortunately, public defenders do not usually assist with this process. A juvenile sex offense can result in eviction of a whole household from public housing. Federal law does not require it, but the Public Housing Authority has discretion to evict a family. Public housing authorities may also refuse to rent to anyone who is registered as a sex offender, even if it is a juvenile offense. For private housing, landlords have more discretion in evicting families that include a sex offender. It is important that youth who have to register comply with any treatment requirements and ask the court to lift the registration requirement when the waiting period is over, which is either 2 years or 5 years, depending on the offense. This will make a big difference when applying for public or private housing.
Sometimes youth are detained for brief periods of time due to an arrest or an allegation that they violated the law. Being released from detention, even without a criminal adjudication, can result in a loss of housing. This is especially true for homeless youth and youth in foster care. Sometimes being detained can lead a foster home, a group home, or a shelter to decide to terminate a youth's placement in that home or facility. Sometimes the arrest causes a family to be evicted from their rental, and the entire household may now face homelessness. Many youth have to rely on friends, relatives, or other safe relationships to find informal places to live if they are temporarily without a housing option due to a juvenile justice contact. Sometimes foster youth are moved from one home to another after a stay in detention. In some cases, where the crime victim is a family member, judges order the youth to not live in the same household. This creates a housing crisis for the youth and the family. The youth's parents are always responsible for providing their children with a safe place to live, even if the court orders the youth to live outside the home. When parents have a landlord who wants to evict the entire family due to a youth's juvenile record, the parents may decide to stay in the rental home without the youth. the family is obligated to make arrangements for that youth to live somewhere else. Parents can never stop taking responsibility for their children, even if they get a juvenile record that impacts where they can live. This can be a very difficult situation for families and often requires the family to reach out to their friends and relatives for help. The Children's Administration, or sometimes called DCFS or CPS, is the state agency responsible for taking care of children who are removed from their parents due to abuse and neglect. But that agency is not obligated to find housing for youth who cannot stay with their family due to juvenile records. If there is a youth who is living on the streets or is homeless, there may be some homeless shelter beds available nearby. Sometimes these beds are called Hope Beds. Hope Beds are designed for youth who are under the age of 18. The best way to locate one is to call 211.
In the resources box at the right of your screen, you can find links to websites with information about your rights when facing eviction. In Washington, you have certain rights as a tenant and may have a defense to eviction. You may have more rights if you are in public housing. Also linked on the right side of your screen are a variety of housing justice projects, which focus on helping people protect their housing. The best way to keep your juvenile record from affecting your housing in the future is by sealing your juvenile record. Before applying for housing, you should check with the court to see if your juvenile record has been sealed. In some cases, juvenile records are automatically sealed when you turn 18 and you meet certain conditions, like paying off all of your restitution. If your record isn't automatically sealed, you can go through a process to seal your record. Please see our web tutorial that provides more details on sealing. A landlord may ask you to provide a background check yourself. If this happens, get your background check through the Washington State Patrol, not through a private agency. The Washington State Patrol will not include non-conviction data, like dismissals, and they update their records regularly, so sealed records should not appear. The same is not always true of records maintained by private background check companies. If you know that your record has not yet been sealed, and if you are not eligible yet to get it sealed, private individuals can be easier to rent from than companies. Finding landlords through friends and family could be your best option. Finally, if you are denied housing based on your juvenile record, you may also have a claim for discrimination. There are federal and state fair housing laws that protect renters from unlawful discrimination. It is always good to get some help anytime a renter feels a landlord is being unfair. For example, you should not be denied housing only based on arrest information. The fair housing laws protect renters in all kinds of housing situations, including rented apartments or houses, cooperatives, rooming houses, temporary shelters, mobile home parks, and roommate situations. The Washington State Human Rights Commission enforces discrimination laws. There are also some local government human rights agencies that enforce discrimination laws, like the City of Seattle Office of Civil Rights and the Tacoma Division of Human Rights. Links to these and other fair housing offices located throughout Washington are available on the right side of the screen.
On the right hand of your computer screen, we've uploaded links to help you find more information about the topics discussed in this web tutorial. To navigate to the web pages, click on the subject, and then click on the button below that says Browse To. Thank you for listening, and we hope the information helps you in securing safe and stable housing.